Cliff Decker-Hofmeyer says there could be dire consequences for employees recording the activities of their employers. Just what are the rights and limitations of employees when it comes to this matter? For more on this, I'm joined by Michael Yeates. He's a director at Cliff Decker-Hofmeyer's Employment Practice Division. Michael, thank you so much for your time tonight. Now, it's not something that as employees we often consider, the fact that there is a certain level of privacy that those that we work for, the institutions that we work for, need to be afforded. How did this statement even come about? How did this issue come about? What sparked it?
Well, Kathy, thank you very much for having me. I think what's important is that we must realize the day and age that we're living in, everybody, or at least most employees, are walking around with very advanced devices in their pockets, whether it's a cell phone that can take videos and photographs or even record conversations, that it's very easy to step over the line and actually record or take a sample of something which is not necessarily available in the public domain freely. Something that your employer would regard to be rather confidential or even vital to the success of the business itself. So we have seen certain cases permeating through the Labour Court where employees have actually been dismissed for taking photographs of manufacturing facilities, manufacturing processes, confidential strategies, marketing strategies. And what they want to do with that information is up to the employee himself, I suppose. But it is a right that the employer has to try and protect.
I imagine that a lot of it also comes down to the protection then of the space of the employer. But you talk about the use of mobile devices, and I'm wondering, people take so many pictures these days, and of course employees have access to different, different places within an actual building. So at which point does somebody know that I'm crossing the line or I'm not, even if the intention perhaps is not bad, but by virtue of the background that could be overexposing?
Right. So look, not every employee is a legal learned person or a lawyer. And to overstep the line could potentially be innocent or it could be malicious. The best thing for employers to do is obviously to educate their employees as to what is allowed and what isn't allowed. It's very easy for an employer to actually instill a workplace rule where cameras are allowed, where cameras aren't allowed, what you are allowed to record or not. For instance, if you are having a strategy session on marketing or where you would like to try and grow your business, you could have a workplace rule to say that these conversations or these meetings will not be recorded and may not be recorded, and other employees must check their cell phones at the door or at least sign some form of acknowledgement that recording devices are not allowed. We see these kinds of regulations either in workplace policies or in IT policies, for instance, when regulating how you use your laptop computer or anything of the sort, but also very often in the employment contracts, where the confidentiality obligation of employees are normally stipulated.
What if one is recording perhaps part of a meeting that they're a crucial, role player in, and they just want to make sure that they're not missing anything and something to go back to and be able to listen to? Is it illegal for one to do that? And if you get the necessary approval, can you go ahead?
It is not necessarily illegal to do so. A lot depends on the type of environment that you're working in and what your workplace rules entail. There's a good dose of common sense that should also be incorporated here, when employees should know when information is sensitive and what they do with that information. It's not so much the recording of a conversation wherein the mischief lies, but it's really in what you intend to do with that information. And where we have certain examples of employees trying to record information or take information out of the workplace to use for their own benefit, or to perhaps go and sell onto a competitor, or to make themselves more marketable to another competitor, for instance, that's where the mischief and the danger particularly lies.
Is there precedent where people have lost their jobs as a result of incidents of this nature?
Yes, absolutely. We've seen certain cases go through the Labour Court. I can recall a particular matter where an employee was caught taking photographs of his employer's production line. The employer saw that he was taking photos. They asked him whether he would please hand over his telephone so that they could see what photographs he had taken, or at least confirm that he had deleted the photographs, which they've requested him to delete. Now, this particular employee firstly refused to hand over the telephone, and secondly, when he went through the CCMA process, he denied taking these photographs. The long and short of that case really surrounded the reasonable expectation that the employee may or may not have to privacy when balanced against the employer's right to protect their own interests and rights. The CCMA basically found that where you take, for instance, photographs or record conversations, and it has to do with your employer's business, your employer does have a right to access your device or something of the sort to protect its interests. And you do not, as the employee, have a reasonable expectation to privacy, as we would ordinarily expect in the ordinary course.
Sure. So then what do both parties have to do to protect themselves? So in the instance of a picture, you're in the foreground of this picture that unfortunately an employer then feels exposes something about their business that they don't want out there. What rights do you have if you've already made such a picture public, but your intention wasn't necessarily bad?
Look, I think firstly you need to consider whether the information in that picture, for instance, whether it could potentially be harmful to your employer when it becomes exposed to the public domain. I mean, you would think, what is the harm of photographing an employer's production facility? But for instance, that could give away details or clues as to the manufacturing process, something that could be proprietary or even a trade secret to that particular employer. The most important thing that the employee really needs to ask themselves is whether this particular information is generally available to the public. If it's not, rather err on the side of caution and not take that photograph and not record that conversation if it's not generally recorded, unless if you've asked somebody if you can record or take a photograph of that.
All right, so it sounds like people, because you do see it online a lot, where people are at work, they're taking videos, some of them are just making fun or whatever the case might be. Do people need to be thinking about it as hard as that?
I think people just need to be aware of it. Employees need to be aware of it. And I would go so far as to say that there is some obligation on the employer as well to educate its employees, whether it's in terms of workplace rules or policies, whether it's in terms of your contract of employment. Employers need to step up as well and educate their employees. A lot of employers don't take that extra step to tell employees what may be acceptable and what may not be acceptable. But then again, it also depends a lot on how the employee reacts when he or she is caught out.
Sure.
Well, one of the biggest problems that we do, well, I don't want to call it a problem, but one of the challenges that we've got is social media. And we do often see videos or posts going onto social media which may contain content which all of a sudden either embarrasses an employer or puts his or her employer into a precarious position. And there are many examples and cases where employees have been dismissed and fairly dismissed for posting things on social media which they were not supposed to post on social media.
Sure, that certainly does give one a lot of food for thought. Does it include even perhaps footage of wrongdoing by the employer? So
here we deal a lot with internal policies and procedures, whether the company or the employer does have a whistleblowing process. For instance, if you see something being done by the employer that is wrong, what is the normal internal process to escalate that? Do you take it to your manager? Do you take it to his or her manager above him or her? But to immediately go out into the public domain may not always be the right step. Granted, there may be opportunities or situations where something like that may be unavoidable or necessary, but rather take legal advice before you do something like that, because that is a pretty drastic step.
All right. Well, it certainly is a lot of food for thought then for all of us to think about. Michael Yeates, he's the director at Cliff Decker Hofmeyer Employment Practice Division. We're going to take a short break.